Richard and Jocelyn for inviting me and all of you coming out tonight. I understand this is part of a course I guess you've been having over the past number of weeks. My presentation is, I'm going to warn you now, it's about an hour long. In order to get the full picture of how we got to be where we are now, I have to start from the beginning. And a lot of people, when I talk, they say, Russ, you're not going to start with Christopher Columbus, are you? And I say, no, Jacques Cartier. So I'll just get into it. So I have several parts that I want to cover. The historical context of colonialism. And of course the key Liberal platform promises, because they promise to fix the colonialism and, you know, come up with a new relationship. And what they've done since they formed the government. And then I want to talk about the recognition and implementation of rights framework, not just the impacts on land terms policy, but the issues of self-government, self-determination, and then my conclusion. So, of course, the early contact started to change with Jacques Cartier, Samuel de Champlain, and John Cabot out in what they call Newfoundland. That was the beginning of change for us. Certainly the Haudenosaunee and the Anishinaabe Nations in the Northeast, right over to the Micmacs, but coming up to St. Lawrence were the ships, you know, that started to change around here. Canada bases its territorial integrity and assertion of sovereignty on two doctrines. In Quebec, it's terra nullius, because the French explorers and those who occupied viewed Indigenous peoples as being savages or non-humans, certainly non-Christians or infidels. So that doctrine of terra nullius really, I would say, applies in Quebec, because the rest of Canada, under the English term, they relied on the doctrine of discovery, you know, planting a flag for the sovereign. But those are the two doctrines that Canada relies on for its territorial integrity and its sovereignty, its assertion of sovereignty. And the first recommendation of the Royal Commission on Aboriginal Peoples was that the governments and courts should stop relying on these racist, outdated concepts. But of course they put that on the shelf, and even Trudeau, who's cherry-picking the Royal Commission report now, is ignoring that recommendation. So, prior to contact with Europeans, Indigenous nations, we made treaties and agreements between each other as Indigenous nations. So when Europeans started to show up on the shore, they were incorporated into our pre-existing tradition of having agreements made and signified through wampum. And the two-roll wampum, of course, is one of the ones that's been mainly talked about, I think, publicly by many people. And then that's the Hiawatha belt that represents the Haudenosaunee Confederacy. So these belts, you know, were what we used to signify agreements between ourselves, and then we incorporated the Europeans into our treaty-making process that pre-existed contact. These belts here were held by William Commanda, the late William Commanda, who's passed away. They represent, we believe, a number of us believe, these are part of the Seven Nations Confederacy. And we don't talk about the Seven Nations Confederacy much, but the Seven Nations Confederacy were the allies of the French who surrounded Montreal, and basically were from the missions. And there were 7, sometimes called 9 communities that formed that confederacy as allies. And in 1760, there were treaties of peace and friendship made here in this area. Barrier Lake, they say that this wampum belt, the 3-figure wampum belt, their memory and reading of it says that it represents the Indian nations and the French and English-speaking nations, and that the cross is there because the priest witnessed the the agreement for the Vatican. That's their reading of this belt. And they're saying the Indian nations were always supposed to have consent over anything that happened in their territory. We believe this belt was made around the time of that 1760, because there were the Articles of Capitulation. There was reference in there that Indians will keep their lands and their religions and everything as well. But I don't know if that's in there. Yeah. So around what's now Cornwall on the St. Lawrence River, there was a Treaty of Oswegatchie, and that was made with the Seven Nations Confederacy, the representatives of the Mohawks, you know, the Abenakis, the Hurons, the Algonquins, who were members of that Seven Nations Confederacy. And the first agreement was with Sir William Johnson. It was to get us to remain neutral, because we controlled the waterways, you know, traveling up the St. Lawrence River or the Ottawa River. If you didn't have agreement with the Indian nations, you wouldn't get very far. So they asked the Seven Nations Confederacy, who were the allies of the French, to remain neutral. And the British marched on Montreal and, you know, defeated the French in Montreal. And there was a Treaty of Kahnawake in 1760, where the relationship with the British of peace and friendship was cemented. And that brought the Seven Nations Confederacy in with the Haudenosaunee Confederacy, who already had an agreement, you know, the two-row and the covenant chain relationship with the British. So this started to bring the Anishinaabe nations in with the Haudenosaunee, and also the Haudenosaunee, who were allies of the French. It's kind of a touchy subject, that's why we don't talk about it too much. There was some friction, but this is these belts, we think, represent around that time. Now, there were lots of the doctrine of consent, you know, was represented in the belts that were made. This belt here it's on the other side, it says 17 and then 64. That signifies the Treaty of Niagara belt, because after the Royal Proclamation of 1763, which was supposed to stop settlers from trespassing on Indian lands, and also that it's set up under British law that you know, settlers couldn't buy land from the Indians, only the Crown could. So they set up the rules amongst themselves about that through the Royal Proclamation. But the Treaty of Niagara reinforced those early treaties of peace and friendship from 1760, because they also had them with the Micmacs out on the Atlantic region. So there were peace and friendship treaties with the Micmacs from the 1750s. And that all culminated in this huge treaty gathering with thousands and thousands of Haudenosaunee and Anishinaabe nations showing up there to make a treaty with the British. And so that's why when the War of 1812 came, it was you know, Indigenous warriors who were at the front lines fighting the Americans and repelling them from coming into what was considered to be Canada at that time. And my understanding is that thousands of Indigenous warriors died in that fight. And it was after that, I would say around here, about 1830s or so, that we started to get outnumbered. And that's when we stopped being treated as allies, and the government started to treat us more as subjects. And this is a map of the historic treaties in Canada. You can see in the Atlantic, they have the peace and friendship treaties there. But they don't have the peace and friendship treaties here that I just referred to, because none of the nations have brought that out to the governments yet to talk about it. But I know about it because I've been working with Algonquin governments for 30 years now, and I've seen their research, and I know that those treaties exist. And it wasn't just with the Algonquins, the Mohawks are part of that as well. And like I said, it hasn't been brought out, so it's not on any official map yet. But the rest are in Ontario, were some of the earlier historic treaties, and then the numbered treaties across the prairies that they made with Great Britain, not with Canada. That's an important point to note. We'll note that all these pre-Confederation treaties and these numbered treaties were all made with Great Britain, not with Canada. Canada didn't exist. So in 1867, the British North America Act was adopted. That was Canada's first constitution, with Canada being a British colony. That first constitution was devastating for us as Indigenous peoples in Canada, because it divided powers between the federal government and the provincial government, but it didn't recognize any of our jurisdiction. We were excluded. We became a subject matter under Section 9124, where the federal powers, these are heads of powers that the federal parliament can pass laws over, included us as Indians and lands reserved for the Indians. So this is the constitutional authority that Parliament used to pass the Indian Act. So when you're talking about the Indian Act, it's just legislation. But this is the constitutional authority that Britain gave to Canada as the successor state, to pass laws over Indians. Like I said, we were outnumbered, and that's when they started to pass laws over us without our consent. And then these other areas, of course, are areas that the government has powers over today. And then for the provincial powers, like here in Quebec, they had the powers over management and sales of what they considered public lands, even though they didn't make treaties with us about acquiring these lands. As the Royal Proclamation said, they ignored the Royal Proclamation. Before they started handing out lands to settlers in Quebec, before 1867, in violation of the Royal Proclamation. And then after the Royal Proclamation, of course, they continued to do that. But what they call Indians, under the Indian Act or in the Constitution, were stuck between federal and provincial jurisdiction, because natural resources, of course, became a matter of provincial law. So setting foot off reserve to hunt, fish, and trap, that's where you'd run into being in conflict with the law. In fact, the first court cases involving Indians in Canada were in the 1960s, the high-profile ones, and they all involved hunting and fishing. Those were the first issues when Indians were being charged with violating provincial fish and game laws. And the Indians were arguing, we have treaty rights, so we don't need to respect your laws. And that started the court cases that evolved into what we're dealing with now on much larger constitutional issues. So anyways, this first constitution was devastating. Like I said, they passed the Indian Act in 1876. That's still in force today. They have amended it from time to time, as I guess you probably heard in the previous weeks. It's still an instrument of control and management. They still define who an Indian is, who can be registered. So membership becomes an issue. But I always liken it to pulling on a blanket. You just can't talk about membership because it's all connected. The Indian Act is one piece of legislation from the 19th century that set up basically village councils with limited powers under the model that they used. So all the provisions of the Act, really come into play around the governance of reserves. The other thing a lot of Canadians don't know about is Canada had a pass system. After the rebellion of the Métis and RIRF, there were Indians involved, not just Métis, and some were hung for the rebellion. But they instituted a pass system. And there's a good film out by Alex Williams called The Pass System. If you haven't seen it, you should watch it, because he documents in there. He found some of these passes in a museum in Lethbridge, Alberta, because these passes were only used in Saskatchewan and Alberta. They didn't use them on us here in the East. They used them for those wild Indians. And they lasted until about the 1940s. But the government set an edict out asking everybody to return the passes to Ottawa so they could destroy them and destroy the evidence, because this system was illegal. And the RCMP said it was illegal and they didn't want to impose it. But Sir John A. Macdonald said, you will impose it, because he wanted to settle the West. He wanted to build the railroad. He wanted to open the lands up on the prairies, for immigration from people, from Europe who wanted to come and settle in Canada and do farming. But these pass laws especially in Saskatchewan and Alberta, if you didn't have a piece of paper leaving the reserve signed by the Indian agent saying which day you can leave and when you have to be back by and for what purpose, you could be put in jail by the RCMP. And they use these passes to stop them from going to see their kids in residential schools too. And in fact, South Africa came to Canada and learned about these passes, and that's what they used in South Africa for the Bantu states. They got their ideas from Canada about the pass system. So 100 years after Confederation, after the British North America Act was mentioned, Jocelyn mentioned the white paper. I'll get a little more in detail. What the white paper proposed was to eliminate Indian status, dissolve the Department of Indian Affairs within 5 years, abolish the Indian Act and remove Section 9124, the constitutional reference to Indians and lands reserved for Indians, to convert reserved land to private property so that it could be sold by the band or its members, transfer responsibility for Indian affairs from the federal government to the provinces, and integrate their services into those provided by other Canadians to other Canadian citizens, provide funding for economic development, basically on a transitional basis, and to appoint a commissioner to address outstanding land claims and gradually terminate those existing treaties. The number of treaties, and they weren't even recognizing the pre-Confederation peace and friendship treaties in 1969. They weren't even on the radar then. But I've got correspondence that said after Indians organized and created organizations to fight the white paper, including in Quebec, it was the Indians of Quebec Association, Union of Ontario Indians, Union of Nova Scotia Indians, Union of BC Indian Chiefs. A lot of the organizations used the labor model because a lot of the leaders were in the trades. And so that was a model that they knew, the union model. So they also know how to go after management, which is the federal government, right? So that's why they formed regional organizations, and the National Indian Brotherhood became the national organization. That's the organization that pre-existed the Assembly of First Nations, which is there now. But those organizations were set up to fight this plan. But according to internal documentation from Indian Affairs, from the Assistant Deputy Minister level, from Chrétien to Trudeau, they said the plan is good, even though the Indians rejected it. You just need to get rid of the 5-year plan and make it long-term. We're going into 50 years now, next year of the white paper. And instead of it being a package, go after this in components. So they broke it apart into pieces. And as you'll see, as I go through, they've been working on the pieces since then. And that's what this framework is about too, is these objectives are still being pursued. Now, of course, in 1982, we had a new constitution come. On April 17th, 1982, the Queen signed it into law. And when this was being negotiated, they had a section in the new Constitution code that said, we hereby recognize and affirm the Aboriginal treaty rights of Aboriginal peoples. Well, Alan Blakeney and Premier Lougheed from Saskatchewan and Alberta said, we want that section removed. Interestingly, where the past laws were, right? Saskatchewan and Alberta. Those premiers in 1980-81 said, we want that out of here. We don't want that in the new Constitution. Well, of course, when that was removed, Aboriginal groups across Canada and with Canadian supporters organized and demanded that the section be put back into the Constitution because it was being negotiated between the federal government, Chrétien as the Justice Minister and Trudeau as Prime Minister, and the premiers and the leaders of the territorial governments, mainly the premiers. And so they were doing horse trading, and what would be in what was called the Canada Bill eventually. And so Section 35 was reinserted, but they inserted a word. It now reads, and it's in there now, it says, we hereby recognize and affirm the existing Aboriginal treaty rights of Aboriginal peoples. And what the courts have said, the word existing means those rights that existed as of April 17th, 1982, when the Queen signed it into law. Because before that, the government, under Canadian law, could have unilaterally extinguished, Indian rights. They didn't need consent. But now with this new constitution, they do need consent regarding Aboriginal treaty rights. But they have different ways of getting that, as I'll get to. So anyways, Section 35 is that section now that recognizes and affirms existing rights. And that was amended in 1983. When the Constitution was adopted, they had Section 37 in there. That's an important section to know about. That section said the Prime Minister, within 1 year of this becoming law, so as of April 17, 1982, before April 17, 1983, the Prime Minister had to convene a First Ministers' Conference on Aboriginal matters to identify and define what Aboriginal treaty rights means in Section 35, in other words, to define it. So they held that in March of 1983, and they amended the Constitution under the Constitution Amendment of 1983. They added in Section 35(3), which said for greater certainty, land claims agreements that now exist or may exist are treaties within the meaning of Section 35(1), which is the main part of Section 35, recognizing and affirming Aboriginal treaty rights. But it was the Grand Council of the Crees and other groups who were negotiating what they call modern treaties who pushed to have that section of the Constitution amended so that the James Bay Agreement would be constitutionally protected, because it was signed in 1975 before this Constitution. So they pushed to have it retroactively applied to the James Bay Agreement, and then what became, the Council for Yukon Indians Agreement, and now Nisga'a and others, have signed since then. But that word land claims, any land claims agreements that have been settled or may be settled, comes from 1973, when Trudeau was Prime Minister and Chrétien was Minister of Indian Affairs. The Nisga'a won a court case. It was split. Actually, they lost on a technicality. But 3 judges said the Aboriginal title exists. 3 said it doesn't. 7 judges said you didn't ask the, Lieutenant Governor to be sued, so I'm ruling against you. But it was enough to scare Trudeau, who denied that there were rights before. He said, well, maybe you had more rights than I thought. And, they were funding the James Bay Agreement and starting the Mackenzie Valley Pipeline and other big mega projects. So they became concerned, about the results of the court case. So in 1973, they announced the land claims policy. They said we'll negotiate comprehensive claims in Canada where no treaties exist, land treaties. Specific claims which are lawful obligations, like where a treaty was promised and the reserves are promised in the treaty but not delivered. Mismanagement of trust funds that the federal government held. Those are specific legal obligations called specific claims. They had a third category talking about claims arising out of the Royal Proclamation, but they dropped that. So now you only hear them talk about comprehensive and specific land claims. But anyways, that word land claims started out in policy and they entrenched it in the Constitution in 1983. And I think it's significant because I think it's reducing our pre-existing sovereignty and our territorial rights, particularly if you enter into modern treaties, which aren't the same as historic treaties or the original treaties. So those talks in the 1980s failed. The Section 37 process in 1983, they added on 4 more constitutional conferences. The last one was in 1987. So they weren't constitutionally required to hold any more constitutional conferences, because that section became empty or spent. And the Charlottetown process, Moroney invited them to the table to be part of it, but he wasn't constitutionally required to do so. And that failed in a national referendum anyway. So Section 35, it fell to the Supreme Court of Canada to start interpreting what Aboriginal treaty rights mean in the Constitution. So the Supreme Court, the first decision was in 1990 with the Sparrow decision. Since then, they've handed down numerous decisions laying out legal tests and principles, which now constitutes a legal framework. And it costs millions and millions of dollars to collect the historical and cultural information to launch a case asserting Aboriginal treaty rights as Section 35 rights. Most bands in the country can't afford to do it because they rely on transfer payments from the government. The government knows this. So, despite 30 years of Supreme Court decisions interpreting Section 35, In 2007, the United Nations General Assembly adopted, after 25 years, because I was involved in some of the meetings in Geneva developing this with some Algonquin chiefs I worked with. After 25 years, the General Assembly adopted the United Nations Declaration on the Rights of Indigenous Peoples. Canada, New Zealand, Australia, and the United States voted against it. Those 4 countries voted against it. I think 211 or so voted for it. There were some abstentions, but there were 4 no's, and Canada was one of them. Now, there's 46 articles, I believe, and these are just some select ones I pulled. I should have had 46 because 46 said you can't challenge the territorial integrity or sovereignty of the member states of the United Nations. Canada's kind of using that one to push this framework because they're kind of trying to say, well, we have sovereignty and it's our land, so of course they still base that on doctrine of discovery, but I'm sure they're interpreting Section 46 to justify what they're doing. But you can't look at Section 46 in and of itself. This declaration is a whole package. And I think the most important right is the right of self-determination. Now, I don't think this UN declaration is the be-all and end-all, but it does represent the minimum standards of the UN for human rights. And, you know, it's not legally binding, but it does set out, like I said, international standards for the treatment of Indigenous peoples by states. And it does represent, an ability to go to the United Nations systems, human rights committees and so forth, and point out how Canada is violating the standards. Article 10, no forced removal without free, prior, informed consent. Free, prior, informed consent doesn't mean anything if you don't have the right of self-determination. 26, 27, and 28, I think, are key articles. Trudeau never talks about these. He says he'll implement, well, I'll get to that. He'll implement the UN Declaration, but he doesn't talk about restoration of traditional lands, territories, and resources. A fair process jointly developed to adjudicate rights to lands, territories, and resources. We've never had any say in the land claims policies from 1973 to now. Canada has just unilaterally issued them and said, this is our basis, we're negotiating with you. If you don't like it, take us to court. And that's why you have groups who can afford to go into court. And then 28 says there should be restoration. If you're not going to return lands, like the city of Montreal, then there should be compensation, to the communities whose lands were taken illegally. Free, prior, informed consent is required for development affecting lands, territories, and resources. Rights from treaties. I know the treaty, Indigenous treaty nations say they don't agree with these agreements and constructive arrangements because they say that waters down the intent of the treaties that they signed, the historic treaties. But nonetheless, this is a good guide. I think the declaration is a good guide to talk about the problems with domestic Canadian policy. Now, when the Liberals came in, they made promises in 2015, during the campaign. And I want to go through some of those to remind us in what they promised. They said they would immediately re-engage in a renewed nation-to-nation process with Indigenous peoples. They prioritized developing in full partnership with First Nations a federal reconciliation framework. That's what we're talking about now, is this framework. The framework will include mechanisms to advance and strengthen self-government, address outstanding land claims, see they're still using the word land claims, not land rights, and resolve grievances, they call them, instead of claims, with both existing historical treaties and modern land claims agreements, and that they would enact the 94 recommendations of the Truth and Reconciliation Commission, including the adoption of the UN Declaration, which I guess you went through here, the TRC recommendations. I don't think that those recommendations are enough to deal with the racism and colonialism in Canada myself, the 94 recommendations. He also promised to recognize and respect Aboriginal title and rights, but then he has a proviso in accordance with Canada's constitutional obligations and those enshrined in the UN Declaration. So it's their interpretation of the Constitution and the Declaration we're dealing with, their unilateral interpretation, not a joint process to jointly agree to what it means. They promised to lift the 2% cap on funding, which a Liberal government put in place. It was Jean Chrétien. Paul Martin was Minister of Finance in 1995 that put the 2% cap on First Nations programs, which haven't kept pace with population growth or inflation. And I would argue they still haven't dealt with it, although they did promise to establish a new fiscal relationship. But as far as I can see, they haven't addressed it. They endorsed the recommendations of the Eford report. Now, Douglas Eford was a lawyer from Vancouver that Bernard Valcourt, when he was Minister of Indian Affairs under Harper, retained to review the comprehensive claims policy. But they never even made mention in that report about the Chilcotin decision. And the Supreme Court of Canada in 2014 ruled that the Chilcotin Nation, at least the Honeycoteen part of the Chilcotin Nation, proved that they had Aboriginal title to part of their territory. He didn't even mention that, the implications for the comprehensive claims policy and that Supreme Court ruling. But in that Chilcotin decision too, the Supreme Court said the radical or underlying title belongs to the Crown, which again shows they're relying on the doctrine of discovery. So we still have work to do because they're ignoring the Royal Commission's recommendation to stop relying on it. And the court is still repeating it as justification for keeping stolen lands, territories, and resources and not restoring them or giving restitution. But they promised to. His recommendations don't really deal with all of that, Eford, but that gives them something to go by. Now this is a big one. They promised to undertake a full review of regulatory law, policies, and operational practices in full partnership and consultation with First Nations to ensure the Crown is fully executing its consultation, accommodation, and consent obligations, including on resource development and energy infrastructure project reviews and assessments in accordance with our constitutional and international human rights obligations. Again, this is their interpretation of constitutional and international rights, because obviously there's Trans Mountain. How does this square with the Trans Mountain decision? You know, even the Court of Appeal said that they didn't consult properly. Then they went and bought the thing. So what have they done since they formed the government? Well, one of the first things that I noticed is that there was a public event organized by The Economist magazine in Toronto in the summer 2016, and nobody really talked about it. Even it was somebody from Manitoba that pointed this out to me. But it's on video, and what Trudeau says in there, they asked him about how to deregulate interprovincial trade within Canada, and Trudeau said the way to get that done is not to sit there and impose. The way to have that done is to actually have a good working relationship with the premiers. Of course, he was representing federal government, so with the premiers, municipal governments, and Indigenous leadership, because Indigenous governments are the fourth level of government in this country. Now that's pretty telling, I think, about whoever briefed him, because I know he didn't dream this up on his own. I think it probably came from the clerk of the Privy Council, Michael Warnick, who was Harper's deputy minister for 10 years of Indian Affairs. So that's the thing you have to keep in mind, that Prime Minister and his ministers aren't experts in any of this stuff. They rely on the bureaucracy and sometimes they bring in special advisors, but the bureaucracy really is who's giving them the ideas. And under Warnick at the clerk, because the Privy Council is what they call the government center. That's what feeds into cabinet. Treasury board's in there too, controlling the money. But under Warnick is an oversight committee of deputy ministers, and below them is assistant deputy ministers committee. And they were looking at all these negotiating tables across the country, making sure that nobody's setting a precedent that violates the national objectives and standards that they have in mind, that they're imposing in this framework. So in December 2016, Trudeau announces this two-track reconciliation process. You can see the leaders of the First Nations, Inuit, and Métis organizations standing behind him. That's what the government's done, is they've taken a top-down, secretive approach using the national Indigenous organizations rather than talking to the people who have the rights, which are the people in the communities and nations. So he's been taking this top-down approach using those organizations. And this two-track approach that he announced, basically, remember there was the old constitution and the new one? Section 9124 says that feds can pass laws over Indians and lands reserved for Indians. they're still passing federal legislation using that constitutional authority. And in Section 35, the Supreme Court has mostly, for the past 30 years, issued legal principles and objectives interpreting that. But now the federal government's been doing it through policy. They basically get cabinet mandates, and that's how they can negotiate a modern treaty. But they have national objectives in the treaties, like the Nisga'a Treaty of 2000, Tawasin, Manaus. These are some of the modern treaties in BC they've signed. But they all have key clauses in there, to extinguish. Even extinguishment, they use words like certainty, modified rights, non-assertion of rights. They're saying, oh, we're not going for extinguishment, but they always come up with some clever legal term that they can use to argue later in their courts to say, well, yeah, you did extinguish. Look at this agreement. This word is right there, and this is what it means. That's why they put the word existing back in Section 35, was to limit future interpretations of Section 35. Chrétien was no dummy, and neither was Trudeau. They were both lawyers. So anyways, Trudeau said, we're going to look after immediate concerns, and basically that's the on-reserve program and service delivery. The getting rid of the drinking water advisories is a big one that they kept talking about at the beginning. Section 35, that's the recognition and affirmation of existing Aboriginal treaty rights. So those are the two tracks that he's focused on right from the beginning. And using AFN, they signed a fiscal relations table in July of 2016. That goes to that promise of lifting the 2% cap and coming up with a new, basically new funding agreements, a new funding arrangement. And so Carolyn Bennett and Perry Belgrade signed that, and they've set up technical working tables across Canada. Some of our communities are involved in those tables. This comes from a report issued in December of 2016. I extracted it from that report. It was a joint report by AFN and the Government of Canada. And the thing that struck me about this, most communities are dependent on federal transfer payments. That's how they deliver programs and services on reserve. But what the government's been trying to do is offload their constitutional responsibilities for Indians onto the provinces and onto the First Nations themselves. So this is where they're starting to lay out where they want to see these future agreements going to. Increase economic development by growing First Nations businesses, but they're talking about small mom and pop shops. My friend Arthur Manuel used to say, Aboriginal title is a macroeconomic issue, Russ. It's not a mom and pop issue. Treaty rights are a macroeconomic issue. And he argued he got involved in the softwood lumber dispute last time. And after the Delgamuukw decision came down in the Supreme Court in 1996, I believe it was, they argued that Aboriginal title exists in Canada. So he took that court decision, went to the binational panel, and argued that Aboriginal title is not being included in the sale of softwood lumber in Canada, and therefore it's an unfair trade subsidy. And they accepted that argument. He took that same argument to the World Trade Organization, and they accepted his intervention and accepted that. And nobody's been following up on his work since he passed away almost 2 years ago, but I think people need to look at that. Because what the government has in mind is much smaller when they talk about us doing businesses under federal and provincial laws. Resolving comprehensive and specific claims and additions to reserve. Well, again, if you look at some of these modern treaties like Nisga'a, Manaus and that, the land and cash portions of those modern treaties amount to $32,000 per person, maybe 10 to 15 hectares per person. And in exchange, you have to extinguish your title forever, and you get some other benefits, but that's the land and cash portion of these modern treaties. So that's not going to get you too far on revenue generation. Creating and increasing resource revenue sharing, well, you need agreements with the provinces for that, because remember I said provinces have jurisdiction under Canada's first constitution for lands, territories, and resources off reserve. And of course, this is their favorite one, increasing other forms of revenue sharing, such as gaming and taxation, what they call own source revenue. So that's what they're really after, is to say, we'll reduce the transfer payments to you, but you got to start generating your own revenues locally through taxation And they'll call it other things like service fees and things like that, but it amounts to the same thing. Royalties, that's a good one I heard recently. Some First Nations, like land councils, are using that term, but it means taxation. So the other agreement Canada signed, Trudeau and Perry, was in June of 2017 on shared priorities. They had, I think, 8 parts. I just took these ones out because I think this is what stood out to me, is they'd work in partnership on measures to implement the UN Declaration, including the development of a national action plan and discussion of proposals for federal legislative framework on implementation. So for Perry Bellegarde to say they haven't been involved in what's been going on, you know, AFN's gotten like $50 million this year. That's my understanding. I stand to be corrected, but my understanding is it's in the tens of millions that they've received this year because they have shared priorities and are working with the government. And then that other one I mentioned about the promise to change their laws, what they say to decolonize them, AFN was supposed to work on that. And then, of course, to close the gap, that's Perry Bellegarde's famous thing, is we have to close the gap. You know, he's talking about the social and economic gap. But I recently seen internal documents from the Department of Indigenous Affairs or Services, because they're changing the names, that say that they want to close the regulatory gap between reserve lands and municipalities and provinces. So whenever I hear Perry talk about closing the gap, I'm going to think about the regulatory gap, because I think that's really what they're up to, is it's to get rid of the reserves. Now, here's the thing. The Liberals are developing a Canadian definition of the UN Declaration. So in other words, what the UN adopted at the General Assembly is not what they're interpreting and applying in Canada. You need to understand that. Jim Carr, who was the Minister of Natural Resources for Canada in 2016, told the Standing Committee on Indigenous Affairs, you know, that the government's in the process of providing a Canadian definition to the declaration. Government's currently in the process of providing greater clarity to these definitions, and we're going to get there by following a process and a regulatory regime. So they've been laying breadcrumbs out to us for the past 3 years of what they're doing. It's just that our leaders are not paying attention to it. You know, I'm not inventing this stuff. They're saying this. So although they're saying they're adopting it, they're putting their own definition to it. So Carolyn Bennett told the UN Permanent Forum on Indigenous Issues in May 2016, we intend nothing less than adopt and implement the declaration in accordance with the Canadian Constitution. Now, right there is a qualification, in accordance with the Canadian Constitution. She says we've adopted the declaration without qualification. She said that in the previous statement, but they do qualify. And so Canada believes that our constitutional obligations are to fulfill all the principles of the declaration, including free, prior, informed consent. We see modern treaties and self-government agreements as the ultimate expression of free, prior, informed consent amongst partners. But the thing you have to remember is those land claims and self-government policies have preconditions to negotiations, and you have to agree to compromise your constitutional rights and your international rights in order to negotiate under those policies. And a number of groups have done it, starting with the Creed, the James Bay Agreement. Mind you, I give them, you know, some slack. They were negotiating with a gun to their head. The dam was being built while they were at the negotiating table. But that started the process of modern treaties to extinguish Aboriginal title in modern agreements. So all the groups who signed modern treaties, I think there's about 30 of them or so, have formed their own organization called the Land Claims Agreement Coalition. And they have a website, you can look them up. Those are the groups that are pushing for this framework. And those who have historic or the original treaties are saying, wait a minute, this is a different category of treaties than what we have. You're not even recognizing the spirit and intent of our treaties. You're focusing instead on these modern treaties, which are much more limited in scope, arguably, than the historic ones. Same with the self-government agreements. You know, they're saying this is the model that they want to use for recognition of modern Indigenous nations. Jody Wilson-Raybould, same meeting at the UN Permanent Forum in May of 2016. She's the Minister of Justice. She used to be the regional AFN BC Vice Chief. She knows our politics pretty well, but as Justice Minister, I'd argue she's pretty dangerous. Because she has a different loyalty now for the Crown. She is the Crown. So she said there's a need for a national action plan in Canada, something our government has been referring to as a reconciliation framework. And we do not need to reinvent the wheel completely. Within Canada, there are modern treaties and examples of self-government, both comprehensive and sectoral. There are regional and national Indigenous institutions that support nation rebuilding, for example, in land management and financial administration. Well, you're not going to be able to see this, but I thought I'd put it up anyway. And I give this presentation to the organizers so they can share it, and you can eyeball it closer. But basically what it shows is a comparison of land regimes. This column is the First Nations Private Ownership Initiative, where they want to privatize residential reserve lands. It's a bill that they're working on right now and have been for some time. This one is the First Nations Land Management Act. There's 100 and some bands that are either in that or negotiating out of the Indian Act into this regime to develop land codes. And then there's the Nishka Modern Treaty, and Sechelt, they were the first ones to sign a self-government agreement in 1985 under the Moroni government, where basically they agreed to become a municipal type government. That's still basically the model they're using today. And then Tawasin, that's a modern treaty in BC. But transfer of land to non-members, it says what's going on, taxation powers, Section 9124 lands or Section 92 lands. So you'll see in the modern treaties, you can't read this, but trust me, that's what it says. They're trying to convert lands, Indians and lands reserved for Indians. The lands reserved for Indians under Section 9124. They want First Nations to sign agreements moving them over to be under Section 92 as provincial or private lands. And under the treaties, that's what they're getting. So that's part of getting rid of the reserves. Now the First Nations Land Management and Private Ownership Initiative, they're not doing that yet, but they're setting the stage up to change the land regimes from being under the Indian Act to being more familiar with private property and individual property on reserve to break up the collective or communally held lands. So that's what this chart shows, and this comes from the department. A friend of mine got it through access to information in a report he got. So this is part of the evidence I was talking about closing the regulatory gap. So they're really busy on this. Most of our people, excuse me, in the communities don't know this stuff's going on. This is pretty technical, complicated stuff. Even a lot of chief and councils don't know this. Some of the ones that are in it. And this is a summary of the proposals under the Private Ownership Initiative. But the reason why I put these up there is because Jody Wilson-Raybould is touting these as Indigenous institutions, national Indigenous institutions. And they aren't. The federal government created those institutions, and they just have Indigenous peoples on the boards, and they're paid by the governor and council. They're not our institutions, but these are the institutions they're going to use to assimilate us in band by band across the country as part of the framework. And they've been working on this for a while. Some of this pre-exists, the Trudeau government. But it was the Chrétien government that passed the First Nations Land Management Act, which a lot of this is coming from. Harper was the one that was working on the First Nations Private Ownership Initiative, but the Trudeau government's still continuing to work on it, as he is in a lot of the Harper stuff. So Jody Wilson-Raybould also told AFN in July of 2016, adopting the UN Declaration as being Canadian law is unworkable, and a political distraction. Ultimately, she says it will be articulated through the constitutional framework of Section 35. But that also means Constitution Act 1867. So it's very restrictive and very illegal, what they're planning on imposing in this framework. Now, they say there's 3 federal paths to reconciliation. They've created 70 what they call recognition of Indigenous rights and self-determination discussion tables in a pan-Indigenous approach for First Nations, Métis, and Inuit. They already had before Justin Trudeau became Prime Minister, they already had these modern treaty tables and self-government tables in Canada. And there's 56 tables in BC negotiating comprehensive claims and self-government together. And so that's why in BC, the First Nations in BC are driving a lot of this too. Not just the ones who've signed, but those who are at negotiating tables to settle. So that's recognition tables. These are the ones I call the termination tables, the modern treaties and self-government tables. Really, I think they're all termination tables, but these are new. And then resolving specific claims. Remember I said the specific claims are for like legal obligations arising out of treaties, like setting aside reserve land or properly managing trust funds that might have been held for the sale of some reserve land or gravel or timber from reserve. They get put into Ottawa into trust funds to manage for the band, and the band has to request access to the money. Sometimes they mismanaged it. Those are specific claims. So there's a backlog of hundreds of them, and they've been talking to AFN about creating an independent claims body to process getting rid of the backlog. My understanding is the memorandum of the cabinet on creating that independent claims process is stalled. I think it's because they're focusing on the framework. But these are the three tracks or the three paths that they're saying dealing with rights that they have set up. Now these exploratory tables, Joe Wild, who's Assistant Deputy Minister from, he was INAC, Indigenous Northern Affairs Canada. He's now with SIR, Crown Indigenous Relations. He's still an ADM, but he said in 2016, these exploratory tables, that's what they called the recognition tables at the beginning. They're for interpreting new interpretations of Section 35. They could impact on treaty negotiations, self-government powers, and resource management across Canada, amongst other things. So these recognition tables, that's what he's talking about. That's what they're talking about at these tables. Now, in Quebec region, these are the groups that are negotiating at these recognition tables. I don't know what's going on in Kahnawake talks. I asked K103, they were interviewing me about the framework. I said, well, do you know what's going on about at the table? They said, no. Why? Because these are all secret. Community members don't know what their chief of councils are negotiating, what the scope is in there. And this is just the Quebec region. There's other ones in Ontario and in the Atlantic and across the country. But I just wanted to show you, you know, Gunnisadagi and Kahnawake, the councils are at tables there. Be nice to know what they're talking about. But I know what the government's doing is they're using these tables to feed into the framework. Because even though the tables don't talk to each other, the federal negotiators are all meeting in Ottawa and feeding the results of those discussions into what will be in the federal legislation, the scope and content of what they're going to define as recognition and implementation of rights, because it's all about the federal definition of rights, not our definition, theirs. So here's a map showing the modern treaties that have been signed in Canada. You can see in Quebec the James Bay Northern Quebec Agreement. Tawasin is a small little place. Manaulth isn't on here, that's another small one on Vancouver Island. Nishka, but they have 56 tables in negotiation in BC that aren't resolved yet. Most of it's north of 60. The tougher negotiations are going to be down out here in Ontario, Quebec, and the Atlantic, because those are the longest outstanding Aboriginal title claims in the country that haven't been resolved and have all kinds of third parties on them, as you may have noticed. But this is a map of the so-called modern treaties. And this is a map from the department basically showing self-government and comprehensive claims across the country, so you can see the country's pretty well covered. And these are different talks than the recognition tables. These are talks that have been going on for decades, actually. And groups have been dragging their feet because they don't want to extinguish, so they deal with side issues instead. And then, for the most part, the comprehensive claims negotiations are based on loan funds. BC, I think, borrowed $500 million. Trudeau just announced that they're going to stop using loan funds for negotiations, and he said he'd consider forgiving the loans, but they haven't done that yet. They said that in budget 2018. So I'm sure they're going to want some quid pro quo with the groups that borrowed money in what their new agreements will be. So what I'm saying is Indigenous self-determination is being hijacked by Trudeau. Most important rights, Article 3, the right of self-determination. It's the umbrella right. The other articles spell it out in UN in land rights and governance. You know, free, prior, informed consent. If you don't have self-determination, you don't have any of this. And, you know, there is Article 18, I didn't include that, but Article 18 says Indigenous peoples have the right to make decisions through their own Indigenous institutions. Article 19 says governments will negotiate with Indigenous representatives on changes to laws and policies. So Canada's relying on Article 19, negotiating through AFN, but Article 18, I would argue that's the one where they need to be talking to the rights holders, and bands and band councils are not Indigenous institutions, they're colonial institutions. So our people need to start figuring out on our side, how the hell are we going to organize outside of the band council system and structures and have, you know, Indigenous assemblies. You know, Haudenosaunee, we have our own customs and traditions to do that. How are we going to deal with that? Because that involves the people. The Anishinaabe have their customs for doing it, as do other groups in BC. The Crees, they have their own out on the prairies. So we need to start talking about Section 18 and how we're going to organize ourselves for our own self-determination instead of it becoming a federal program to be funded under the government, because that's where it's going now, just like they did with self-government. So Trudeau operates in secret through the following processes. They created that working group to review the laws and policies. Jody headed it up. They have these other ministers sitting on there. And then just recently, under a cabinet shuffle, they created the Cabinet Committee on Reconciliation. So all this work that Jody was heading up, it's been taken over by a cabinet committee headed up by Jim Carr, former Minister of Natural Resources, who's now the Minister of International Trade, I think. You know, Trans Mountain. Anyways, Jody sits on it, but she also sits on it with all these other cabinet ministers. So it says that building on the work of the working group that she headed up, policies related to Indigenous peoples, this committee examines initiatives designed to strengthen the relationship with Indigenous Canadians. So basically the Prime Minister's taken it over by putting it to this committee now. And it, like I said, is headed up by Jim Carr. And Jim Carr in 2016 at one point said, well, we have the rule of law in Canada, and if we have to, we have the police and the army. And he was talking about Trans Mountain, you know, that if they have to, they have the ability to make sure it gets built. And he apologized for that after, but he did say it to the media. But now they've got him chairing this Committee on Reconciliation. So that should tell you something too, about what the real intent is of the federal government. 10 principles on Indigenous relationships. Those were introduced in June, one week, I think, after they signed that MOU with AFN on shared priorities. They unilaterally issued these 10 principles on Indigenous relationships. And if you look at them, they read well, they sound good. But if you unpack them, you'll see it's based on the Doctrine of Discovery, Constitution Act 1867. It's a status quo. They're not changing anything. And it's based on 30 years of jurisprudence. So that means the Supreme Court legal tests and objectives put the burden of proof on us who are asserting we have rights. And again, like I said, that costs millions and millions of dollars to collect the historical and cultural evidence to meet the tests. And they're saying these 10 principles are their new preconditions for developmental policy and law, basically. And they're very prejudicial to rights. And again, it's Principle 10, for example, says that they'll take a distinctions-based approach to First Nations, Métis, and Inuit, but then they want to pass this national framework legislation for all Indigenous peoples, First Nations, Métis, and Inuit, in a one-window melting pot concept. And then they announced in August of 2017 that they were going to dissolve the Department of Indian Affairs and create 2 new departments. Remember I said 9124 and Section 35? I believe these departments are split along those lines. Section 9124, it's dealing with status Indians on reserve, program and service delivery. That's the Department of Indigenous Services, headed up by Jane Philpott. Ministry of Crown Indigenous Relations is Bennett. That's the self-government modern treaty agreements, the legislation, that kind of thing. And then they have, again, the establishment of these recognition of rights tables across the country. And the outcomes of those tables are to contribute to the planned policy and legislative framework. So again, they're in secret. We don't know what it's going to look like until they introduce it into legislation or policy. And they have a majority in the House of Commons, so they could ram legislation through any time. Indian Act bans are considered non-governing because many of them are still governed by the Indian Act. And that means their reserve lands, monies, and other resources and governance structure are managed by the provisions of the Indian Act, by the minister and her departmental officials. So that's why the Department of Indigenous Services is really in charge of a lot of things still. If you want to move out of that, as they say, out from under the Indian Act or beyond the Indian Act, then you have to sign these modern agreements. And here's a self-government fiscal policy they came up with where they define a federally recognized Indigenous government as somebody who signed a comprehensive land claim agreement, which includes a comprehensive self-government component or a comprehensive agreement on self-government. An example of that is the Kahnawake Education Act that just passed through Parliament, I think, within 2 weeks in December of last year. If you read it, it says all their laws have to be consistent with the laws of Ontario. So, I mean, that's their objective, is to get the bands to basically, sit under the provincial order of government. And then the last one is legislative. Well, really, the legislative comprehensive self-government arrangement would apply to that Kahnawake Education Act. CSHUB would fit in under this self-government one. But basically, they're saying if you want to be federally recognized Indigenous government, because Indian Act bands aren't, they're not recognized as having any rights, really. You have to sign agreements through one of these doorways. So in Budget 2018, this is another indication of their framework. They're going to use the funding as a carrot or stick for Indian Act bands to transition to self-government agreements. And those who are negotiating modern treaties our self-government agreements will become Indigenous governments. And so when Trudeau or his ministers say the coming federal framework is to recognize and implement Indigenous rights, it means as unilaterally defined by federal self-government and comprehensive claims policies. So it sounds good that they're going to recognize and implement rights, but they're weaponizing recognition, federal recognition, to include their own, and they're going to use the money to starve you out if you don't go along with accepting the terms of their agreements. You can stay under the Indian Act, but you're not going to get very far. And so this is the two ministers, in charge of the two halves. Phil Potts basically dealing with programs and services. Bennett's basically dealing with how they're going to, get bands to sign these modern agreements with defined definitions of rights. So the Budget 2018 clarifies that the Department of Indigenous Services is going to be promoting achieving better results for funding programs until the Indian Act bands transition to a new fiscal relationship, and are recognizing the federally recognized governments. Those agreements are going to include, like I said, own source revenue, like modern treaties, fiscal arrangements. Trudeau's calling that self-determination. But like I said earlier, the federal definition is saying we don't have to reinvent the wheel. We'll just use these models that exist already, the modern treaties, the self-government agreements, or this legislation like the First Nations Land Management Act, Property Owner Act, et cetera, et cetera. So there's a legislative track, and then there's the agreements, which the legislative framework will basically ratify once you sign. And they're saying they're reconstituting Indigenous Nations. Really, it's about encouraging bands to merge to make it cheaper to deliver programs and services. They're putting aside $101.5 million over 5 years. You can make a proposal to do capacity development to start merging bands, either through tribal councils or new institutions. But this is all feeding into the federal legislative framework that they want to pass ultimately through Parliament. And so they're also identifying $650 million over 5 years for the national Indigenous organizations. That's a lot of money. for what they call bilateral mechanisms. And bilateral mechanisms are basically a fancy way of saying Indigenous Organization Federal Cabinet Committees. Like AFN and the federal government have a cabinet committee. They meet annually with the Prime Minister and quarterly with federal ministers and AFN representatives to discuss issues under their fiscal relations MOU or the shared priorities MOU. In any case, it's far from the community level, and it's basically the National Chief's office and the Prime Minister's office talking at that level with the clerk of the Privy Council facilitating the bureaucracy. So one of the things they've done is they suspended the own source revenue policy for 3 years, I think, and that's because the modern treaty groups have complained that when they signed the modern treaties, it led to chronic underfunding. So what the Trudeau government is doing is they're going to collect research and data for the operating costs of federally recognized Indigenous governments, you know, like the Council for Yukon First Nations and others, Nishka, and they're going to come up with a new funding formula, which will still include own source revenue in it. But that's what they're doing now, because whatever they come up with there is going to affect the Indian Act bands that eventually sign the self-government agreements. That formula will apply to them too. So they're using the new fiscal relations, the money, to get the objectives that they want. They've always done that. But this is this is the biggest restructuring and changes to policy and legislation I've seen in my lifetime. And I've certainly been around since the early 80s, and actually before that, but I was a kid. But I did watch what was going on with that stuff. Which brings us to this recognition and implementation of rights framework legislation, announced on Valentine's Day. Obviously somebody was very happy about it. And it was announced that it would be a bill in Parliament before Christmas break. He wants it to become law before the next federal election. CBC reported the bill is delayed until after the election, but no federal sources confirmed this. The minister's statement that the article was based on didn't say they were delaying it. The reporter told me he based it on background, that the federal government wouldn't openly admit that they were delaying it. But there's another APTN report quoting the same federal official saying they're leaving their options open. They could introduce it before the next election. So I think it was just put out there to try and undermine our no campaign against it. To try and say, oh, don't worry, you know, it's being delayed. Because we're doing a National Day of Action on December 4th. I think it was meant to try and undermine that. Anyways, the Minister for Crown Relations has said that the recognition framework will be enabling opt-in legislation, and that the Standing Committee could consider amendments by the bill in the new year. Well, that may or may not be the case. You know, they're kind of gauging, because different groups are passing resolutions rejecting the framework. Treaty 9, the Union of Ontario News, other chiefs organizations are starting to do that. So that could mess up their Christmas present that they wanted to deliver. So Jody Wilson-Raybould, as I mentioned, she was the AFN BC Regional Vice Chief. She developed an 805-page governance toolkit. It was a proposal based on recognition legislation that was in the Senate, Bill 212, which died in 2013. There is an article in McLean's January of 2017, I think, called Jody's Plan to Save Canada, where she admits that this framework is based on her work as BC Vice Chief. Anyways, in the legislation, they proposed it having different parts: federal definitions, a preamble and purpose, obligations binding on the Crown, which they're going to decide, you know, what they'll respect as rights and what they won't. Implementing the framework, so they want to set up institutions, advisory institutions. Amendments to the Interpretation Act. The minister said that section comes from the Land Claims Agreement Coalition that has modern treaties. So that's a technical amendment that they want to see. And then the framework is not just the legislation, but it's policy. And she said there'll be a new policy as well on recognition and implementation of Indigenous rights. So they announced this in an overview document on September 10th, 2018. And according to that overview document, they said the rights recognition framework, the law if passed, will be a basis for all relations between the federal government and Indigenous peoples, First Nations, Métis, Inuit, including the pre-1975 treaties. That means the historic treaties. I think you covered the Williams Treaty. That was the last historic treaty in Canada in 1923, I believe. So that's what it's talking about there, pre-75. Post-75 was the James Bay Agreement and all the modern treaties that came after. But it's still a pan-Indigenous law. Even though their 10 principles said they're going to take a distinctions-based approach, it's one law for everybody. And they're going to define key terms. Well, they've already defined the inherent right to self-government in the policy, which basically means municipal government. They're going to define self-determination, Aboriginal title and rights. This goes to the Canadian definition of the UN Declaration I said that they were imposing through this legislation. And federal and provincial powers will continue to dominate over First Nations, and provincial governments have a veto over any agreements affecting their jurisdiction. So that just doesn't include off-reserve lands, territories, and resources. That means things like child welfare, education, any matters that touch on Section 92 powers. The provinces have to be involved in the negotiations, and they have to agree to what's being negotiated between the feds and the First Nations, because they want provincial standards to be maintained. So that'll be entrenched in this legislation. It's already entrenched in policy. They want to set up an advisory committee or an institution that will be created because they want to have a recognition process to formally recognize who qualifies to be Indigenous nations or collectives. And they're saying that they would have the authority of a government possessing the legal capacity of a natural person, meaning basically a federal corporation. And this language comes from the First Nations Governance Act that Chrétien tried to push, Mr. White Paper back in from 2000 to 2004. It died, but this is the language that was in there. He wanted to force band councils into that First Nations Governance Act, and that they would, Indian Act bands would be more or less like federal corporations, having the powers of a natural person. And they'd be subject to agreements with the federal and provincial governments where their jurisdiction is affected, and the legislation will include a list of powers for Indigenous governments, which could be amended. But again, those list of powers will be defined by the government once you enter into these new agreements. So it's all one-sided negotiations. I think you get the picture. And the Prime Minister said, like I said at the beginning, these Indigenous governments are a lower order of government than municipalities. They're a fourth level of government and a new order of government, basically, because you're converting your original status before Canada existed to a new status within Canadian Federation. And new funding agreements are to go along with the agreements, and Indian Act's tax exemption will be removed. Right now, under the Indian Act, Section 87 says that property on reserve cannot be taxed, and that's been interpreted by the courts to include income earned on reserve. They've always wanted to get rid of that. They even have a First Nations Tax Commission, a little guy named Manny Jules. 24/7, that's his job, is to figure out how to get into our wallets. So that's what they're after with these modern agreements. Of course, exercising powers to collect own source revenue. And it's the same model they've already been doing under, this isn't new, this is what they've been doing with the groups that have signed modern treaties and self-government agreements. They just want to extend it to the Indian Act bands who didn't go to a table, which is the majority of the bands in the country. They want to use the new law to use existing or newly created national institutions for First Nations, Métis, and Inuit to provide an advisory role to the government, oversight on Indigenous rights implementation, dispute resolution, public education. Well, they already have, the fiscal institutions that they've set up, including the Tax Commission. They've got AFN and other national organizations they can use to help be advisory groups to them. We're not clear on this. Dispute resolution, they want it to be for First Nations, Métis, and Inuit. So again, it seems to be a one-window concept for resolving disputes under this federal law, which could mean why they're delaying the talks with AFN on specific things. I don't know. It's just that this government's not transparent, so it's hard to get answers out of them. And again, according to earlier media reports, they've stated they want to introduce it into Parliament before Christmas and hold committee hearings after, but we'll see. So there was an Indigenous legal experts group that was talking to the Prime Minister officials about this framework, and they've been exchanging information. On August 21st, the lawyers freaked out and wrote this letter to the Prime Minister saying the basic materials we've been provided appear to misstate foundational legal and constitutional concepts, specifically views expressed to us by senior officials about the meaning of co-development, recognition and implementation, Indigenous laws, Indigenous jurisdiction, treaties, Aboriginal title, engagement, consultation, free, prior, informed consent, self-determination, self-government, amongst other topics, are not legally correct. And that's from, lawyers that have been on for a while. And they're conservative compared to me. So when I hear them talking like that, I know I've been on the right track all along. And they also say the initiative fails to appreciate or understand that the legal rights that have already been recognized by the courts in Canada in a multitude of cases where inherent Aboriginal treaty rights have been consistently affirmed for Aboriginal peoples and Treaty First Nations peoples. So they're saying this is basically ignoring the existing case law. So we urge you to take a look at the current path and reset. So this is the lawyer segment. They're also saying, where's Jody Wilson-Raybould? How come she's not involved? She's the Justice Minister. And they should bring her in because she's been in hiding, apparently missing in action for some time on this. But this shows me that it's the Prime Minister's office and the clerk of the Privy Council that are running the show. And that reconciliation committee and that is going to get orders from on high, I think. Jody's still there, but I don't think she's in the lead anymore. So anyways, their concern is current initiatives will only give rise to more litigation as it does not appear to be in accordance with the law of Canada. So even though they're taking a conservative approach, and I don't necessarily agree with them on the impact of the law of Canada on us, they're saying they want to reset too. So they told that to the government in August. It's still going on, obviously they didn't listen to them. So what I'm saying is this whole nation-to-nation process is fake reconciliation. Our people have been deliberately misled and bypassed for 3 years in this secret top-down approach of the Trudeau government, who's using AFN and selected chiefs, leaders, and chiefs organizations as partners. And there's not much time to stop this. What you can do is you can learn about the Articles of the UN Declaration. Even our own people need to learn it, even if they don't agree with all of it, they need to be aware of it to see what's being talked about, because that's the beginning of talking about how international customary human rights law applies to us in Canada. And we all need to know about that, especially if we want to move out of the domestic colonial legal framework that they're trying to reimpose on us, to recolonize us. You can support the National Day of Action, December 4th. Maybe organize an event here in Montreal. Or wherever. You could come to Ottawa. There's 11 a.m. December 4th, there's a rally on Parliament Hill to support the youth in stopping this. There are going to be actions across the country. I don't have a list of them at this point, but I do know I've had indications that people want to do something wherever they are. You can write letters, Indigenous peoples can write letters and declarations. Non-Indigenous peoples can prepare letters and petitions to send to the Prime Minister. Document the opposition to the bill and a process to develop it, because this past 3 years this process has excluded our people. Most of our people don't even know what this framework is because it's been done in secret. And yet, they're talking about passing a law over us that's going to affect us for generations if it passes. So, if the bill is introduced into Parliament, well, then we're into a lobbying strategy. And we're going to have to try and embarrass those racist conservatives and the disorganized NDP as opposition parties to help slow it down, because they'll need to pass this by June if they want it to pass. Because after June, there'll be a summer recess and then we're into an election. So if they do introduce it, we have to at least delay it so it dies in the order paper when they call the election. So these are some things I listed on what you could do. Anyways, that's my presentation.
Your issue really is how do you come together? I think the primary, as a group of First Nations, and turn around and talk about, you know, a framework that you could live with, and coming to some type of agreement that you could present to the government. And so that's, I think, is your main challenge.
Thank you for that. Not to say that Settler Society has got a lot of consensus going on here.
Wait a minute. Exactly.
I think what I'm saying is the top-down approach, the one-size-fits-all approach doesn't work, and that's what Trudeau is trying to do again. Previous governments have tried it, it's failed. The right of self-determination belongs to the people, not chief and council. The right of self-determination is the right of peoples. And the other thing I would say is that Article 3 of the UN Declaration, although it recognizes the right of Indigenous peoples to self-determination, all it does is affirm that the UN Covenant on Civil and Political Rights and Social, Economic, and Cultural Rights apply to Indigenous peoples. You know, Article 1 of Civil and Political Rights say all peoples have the right of self-determination. Now, I mentioned Section 46, where Canada is going to try and say you can't rupture the state, you know, the territorial integrity and sovereignty of the state. But I think any of us that are born as Indigenous peoples, it's our birthright to challenge the sovereignty of the state because it's illegal. It's based on the doctrine of discovery. And this whole notion of all of us coming together in one voice, you know, the Indian Act is what's divided us. Even though we have the common experience of the Indian Act created bands, and even within the bands, you know, it's fostered a lot of division. That's why I think we have to work outside of those colonial structures to rebuild our nations on our terms. You know, I just went through and showed you Trudeau's funding reconstituting of nations, he's funding capacity building, all this stuff sounds really good, but these are all government programs basically to assimilate social engineering, to assimilate us into confederation as a fourth level of government, a municipal type government, an ethnic government. And our peoples need to find their way out of the Indian Act band by band. And if they want to form, you know, confederacies, as we had, then they should do that. But they have to do that. They have to decide that. But the problem is that the government's meddled in our internal affairs so much, you know, including killing people in our longhouse and padlocking them to force the band council system on us. You know, that's the legacy that we have to try and rebuild from. So it's going to be a long process. I personally think only the bands that are going to survive are going to be the ones that have the knowledge and skill to figure out what's going on their lands, not only on the reserve, but around them in their traditional territories, and what their options are. And they're going to have to use GIS mapping and develop databases, modern skills to manage, you know, negotiations or litigation, including international interventions. I think only the bands that are going to develop those skills are going to be the ones that are going to be able to adapt into a modern time, keeping their customs and identity as distinct organized societies alive. But, you know, it's not going to be somebody from the outside telling us how to do that. We have to do that from the ground up. And the Assembly First Nations trying to use it through them. I mean, that's a chief's organization, not a people's organization. I worked there 3 times. I know how it works, and I know how, you know, the National Chief and the executive committees can manipulate the chiefs in their assemblies, which is what they do through resolutions to get the mandates that they want. So that's not the model for us to use. But I take your point. You know, we've got a big challenge, having, you know, our communities, which are often small and scattered. But on the other hand, Romeo Dallaire noted at one point at a meeting that I heard where he said if we all got together and we could shut the country down economically if we wanted to, because we're all located along the critical infrastructure of the country. Just saying. So size doesn't really matter, you know.
I was looking forward to your recommendations about what can be done, and I recognize the idea of democratizing it, bringing Indigenous voices. Happy to hear about allies also being invited, but my concern is there are people who are probably going to be against this in the Canadian public, Have you seen any signs of them getting organized? Anything we should be looking for? And what sorts of things can we do to stop it from turning into some free-for-all, like the reasonable accommodation hearings and the Bouchard-Taylor commissions that led to a lot of peculiar things coming in?
In fact, I was interviewed on APTN yesterday, and I compared the no vote against this framework to the referendum in Quebec and the separation issue, because I think there's a lot of parallels. But I forget when it was, 2, 3, 4 months ago, Angus Reid did a poll, and they said 60% of Canadians don't agree that Indigenous people should have special rights, and it broke it down by region and demographics, and it raised other issues. I forget who commissioned the poll, maybe CTV or somebody. But to me, that was all a result of Trudeau, his success in getting Indigenous issues raised in the mainstream media fairly regularly. But because he's taken this top-down approach which doesn't involve us as peoples, we haven't been, you don't hear our voices in the public discourse about what do we think about how the UN Declaration should be implemented in Canada. I personally think, you know, when the Constitution was shiny and new back in 1982 and 83, there was a special parliamentary committee on Indian self-government, which had Indigenous non-official reps on it, and they traveled the country, hearing witnesses and holding hearings across the country about, you know, what did they think about the new Constitution and self-government and being a distinct order of government and all that. This government's taking a completely partisan approach on how, on the one hand, they say they recognize the UN Declaration, the TRC calls to action, but on the other hand, it's all been secret through cabinet committees, not involving any of the parties or the public. Even this national engagement process that Trudeau announced on Valentine's Day, that his Minister of Crown Relations, Carolyn Bennett's been carrying out, you know, has been very selective. I think she did wind up going to meet with the Council of the Federation, the premiers, to give them a briefing on the proposed legislation. But it's a process that they designed. It was a flawed process, and it's consistent with how they've misled and bypassed our people for 3 years. Because, you know, they don't want to have us involved talking about, well, what do we think on the ground about how the UN Declaration articles should be applied to us as nations. But that's what's got to happen, I think, because we have to start talking about that. Because if we really want to decolonize and get rid of the Indian Act and not be recolonized under a self-determination policy that they're defining, the burden is on us in Indigenous communities to get our act together, to start developing self-determination plans, you know, along the lines of what I said about collecting information and figuring out what our options are, community by community. And if we're going to do it, you know, collectively with as a nation, then we should. But the one thing I'll say is the funding comes down to bands, and chief and councils are all interested in getting reelected. So it doesn't help for nation building, that structure. And in fact, it was designed to break up the nations. That's why they passed the Indian Act, was to break up our nations, our confederacies, and, you know, to get us more locally organized to become municipalities. Because the Indian Act was the first termination plan. All the stuff they're doing now is just trying to complete what they started with the Indian Act. But all the networks that I've been involved with, we've always had Canadians as allies helping us. I don't know more, defenders of the land. We need Canadians to help us because we don't have the numbers to fundamentally change the structure of Canada. I mean, they're doing it, but they're doing it for their reasons to finish us off. If we want to survive, then we're going to have to get some allies. I don't know if I answered your question.
Yeah, thanks.
Yeah.
So I was wondering if you could talk a little bit about how, you know, this and all of the legislation is dealing mainly with language like federally recognized governments, federally recognized Indigenous governments, and so with on reserve Indigenous peoples in Canada. And I was wondering if you could talk a bit about how this legislation and previous legislations are affecting off-reserve communities? And that's it.
That's a good question. Well, like I said, the Indian Act, right, I think there's been an unwritten policy, because I don't believe it's written down, but there's been an unwritten policy of the federal government to keep chronically underfunded bands, to encourage off-reserve migration of, people into the cities. And then they become a provincial responsibility, they go on their welfare rolls and, they don't have to pay for them out of the federal budget. The provinces have to figure out how to take it out. The provinces have been figuring that out, demanding more money from the feds. Like, these regional education agreements, tuition agreements, for the ones that are going to school off reserve, they want to be paid. The provinces want to be paid. Because they're saying you're constitutionally responsible for status Indians, so you pay. And even the Kelowna Accord, which really, that's a myth that the Liberals promoted, but the term Kelowna Accord was coined by the media. I was there, and all it was a press release. There was no agreement. And it was just a press release by the Prime Minister and the Premier saying, okay, they're going to spend this federal money on these programs and services for on and off reserve Aboriginal peoples. But of course that died right when Harper got elected. But I think our peoples need to be organized wherever they are, And the issue about identity and who's who, I know there's a lot of concern about Bill S3 and the creation of new paper Indians by reinstating them back to 1951, and then the second phase after consultation back to 1876. And they're talking about, well, some said 1 million new Indians. Then they reduced it to saying, well, tens of thousands. That's going to be an issue because our identity isn't just, if you look at the Indian Act, it says you're an Indian within the meaning of the Indian Act. But I know for myself that my identity is not based on that card. My experiences, my family, my relations are what shapes my identity. And if we're going to rebuild our nations, we're going to have to recognize our people through kinship, mainly, I think. We know who our families are.
Mm-hmm.
Everybody asks you, who's your father, who's your mother? It's the first question they ask if you show up. And you better have an answer, right? Because they're going to check on their side. And so that's the connection to communities, to family. But you do have people, the 60s scoop and that, that don't have connections to communities anymore. What about their rights? And they had no say in that. They're trying to find their biological families and communities, and I think we have to respect that. That's all part of colonialism. But these existing advocacy organizations, they aren't the bodies to do it, like AFN. They're not the way to organize yourselves. That's why I've always worked through networks, right? They're not organizations, but the networks are more, what do you call it? Informal, and you can get a lot of things done through that informality, because if you start becoming an organization, then you start getting little Robert's Rules of Orders and all that, and it's hard to get things done. But just like the National Day of Action, we called for our people to take action, whether they're on the land in the communities or in the towns or cities, wherever they are, because this framework's going to affect everybody, and everybody has a say. And we need to get our people's voices heard. I just saw that Perry Belgard was saying on the news that AFN now wants to do a public education process. And I told him I don't trust AFN. They've done a miserable job for the last 3 years. So our networks are going to do our own public education. We're going to continue to do that to get to the grassroots, to give our point of view about what we think is going on. Because we're not funded by the government, so we don't have to promote their message. But I agree with you, whether you're living on or off reserve, if you're a member of an Indigenous community or nation, you should have a voice.
Thank you.
And including gender, like women, especially women. My wife, if she was here, she'd be reminding me of that.
Thank you.
Would you take one more question if
you want.
If,
Here, the question.
yeah.
I'm just, yes, no, yes?
Yeah.
I'm just curious, given the previous question and a bit what you talked about in response to this last question. I get the sense a little bit about what all of this might mean should the Conservatives come into power after the next federal election? Yes.
Sure, I think about that. You know, full disclosure, I was one of the ones that helped create the Aboriginal Liberal Commission of the Liberal Party of Canada in 1990. Same time that the Meech Lake, the same week that the Meech Lake Accord died, with Elijah Harper running out the clock. I was Vice President of Policy from 1990 to 94. I helped work on the 1993 Liberal Red Book. You know, even though Craig Chen was Prime Minister and I didn't trust him, you know, we wound up scrapping with him, and I quit the party and fought with him openly. I went to work for Over McCurdy and we fought with him and beat him on a number of things. He had a majority government. But I think our people have to stop relying on the Liberal Party and their more openness to fund assimilation than the Conservatives. Harper was more honest. Harper was more direct. And he would tell you, I don't believe you have those rights. And I'm not going to fund it. I'm capping and cutting your funding, which is what he did. And Warnick, Warnick was the one doing it. The clerk of the Privy Council is working for Trudeau now, implementing this framework, designing the framework. You know, Warnick was the one that spied on Cindy Blackstock, you know, as if she was some kind of terrorist, because she was embarrassing the government, you know, demanding that, you know, she went to the Human Rights Commission and got those rulings that the government needed to fund children on reserve equal to the ones off reserve. Warnick did all the dirty work. Now he's been promoted by Trudeau, and nobody talks about that, you know. It's all about the Prime Minister and his ministers, but they got people behind them that are dreaming this stuff up and implementing it because they control the money. So the Conservatives will come in probably with a tougher hand. I don't see any difference between them and the Harper ideology on Indigenous issues. If you look at where the Conservatives are, most of their ridings are in the numbered treaty areas on the prairies. If you look at a map where it's blue, there's some in Ontario and Quebec, but most of it's out on the prairies. And look how racist they are. I mean, look what happened with Colton Bushy, right? Tina Fontaine in Manitoba. Look at the, already it started, the Conservative wave. You got Doug Ford in Ontario, CAC in Quebec. You got a Conservative government that just was recognized in New Brunswick. You got Palliser in Manitoba. You got Moe in Saskatchewan, Mississippi North, I like to call it. And you have Jason Kenney probably in the spring in Alberta. And then the only NDP provincial government will be in BC, and who knows how long they'll last because they're hanging on by a thread. So by the time Trudeau gets to his election in the fall, he's going to have all of those provincial premiers and organizations, conservative organizations, throwing their money in to try and get him out. And I think the next election will be fought on the economy, you know, and whether they want to keep spending or starting to tone down the spending and directing it more clearly and managing the debt. You know, Canadians are going to have to figure that out, where they want to go. And then Jack Mead's saying, well, I knew once they picked him as a leader, that's it for them, because Canada's a racist country. You know, they're not going to elect a guy in a turban with beer. You know, certainly not in Quebec. I don't believe that would be the case. And other parts of the country too.
Don't forget Thomas Flanagan. Out west, he's listening.
Yeah, I never forget Thomas Flanagan. He's a goof. But there is a right-wing ideology in Canada. We're going to have to fight it. But we need to strengthen ourselves on the ground, and we can't be lurching from federal election to federal election, hoping the next government's going to be kinder to us. That's why we have to do self-determination plans on the ground and prepare our children and their children and their children, if we want to survive, to realize that we have an adversarial relationship with Crown governments. They're not our friends. They call us partners, but you know, it's really the ones that they're partnering with are cooperating with implementing their plan. They're not cooperating with our people. You know, I just lost a good friend, a chief, for 30 years. He died last Thursday. He fought his whole life for rights. Arthur Manuel, 2 years ago, almost now, I lost him. Spent his whole life fighting for land rights. We're losing some of the great leaders. We have to hope in this next generation that, you know, we're going to see young leaders rise. Because if we don't, we're in trouble. You know, I already said when they re-elected Perry, because I ran against him, I said AFN should replace their logo with the the end of the trail there, the warrior and the horse with their heads down, you know? Because they're just going along with the Trudeau government. So I'm not worried about the Conservatives, you know. In a lot of ways, I respected Harper because he was a more honest racist than Justin is. Justin comes and pats you on the back, you gotta check if you're bleeding, you know. So they operate by stealth and deceit, the Liberals. And I know, because I was inside there, I saw how they operated, and I wound up, you know, denouncing them. They haven't changed from Chrétien. In fact, they use the Liberals, it's nepotism, you know. Look at, what's his name, his Minister of Intergovernmental Affairs, LeBlanc. His dad, Romeo LeBlanc, and Chrétien and Pierre Trudeau were buds. So there's kind of like these family dynasties in the Liberals that keep going and getting reelected. Justin's only one of them. But they have other ones, and they have a network. So the Conservatives, I think we'll have to fight them too. But I'm used to fighting with governments. I've been doing it for a few decades now. The thing that I see that has to be different is we have to have our communities build up their strength and figure out what they need to do. They need to start going out internationally too and exposing Canada for what they're doing. A lot of the chiefs don't do that. They run to Ottawa, they don't run to Geneva or New York. But some of them need to start doing that. Hope I answered your question.
Thank you very much for the wonderful talk. Thank you all for coming. A little, yeah?
Thank you very much for the talk. It was very enlightening, and it's really nice to see everybody here also. I'm from Kahnawake, and I came with my friend also from Kahnawake. And I've been thinking about a lot of what you said, what we can do, how to mobilize, and I find it very the message that we can't just rely on ourselves and our community, that we actually have to look at bridging out and developing partnerships outside. Now sometimes in the wake of everything that we've been through in our communities, there's a tendency to be so fearful and to not trust and to not want to really expand in the sense to want to reach out and to how would I say this? Because of all the colonization we've gone through, there's a sense not to want to partake in and things that are not indigenous to us and not part of our culture, that we kind of push it away right now. And some of that, which is wonderful about our communities, is that we have as you know, our culture is alive and vibrant and has been going on for hundreds of years, and it'll still be going on. And there's always keepers in the Wampus, and there's always singing and songs and the traditions carrying on. But one of the things I'm worried about is when you said we're going to be in trouble if we don't start. To me, I think what's important is to keep our traditions and also to be able to expand on it and to learn about things. And as you said, we need to get people to be able to make those contacts and make those connections and to do things that are very technical that we don't always have the skills for. And that's worrisome for me when I look at my community, is that the fear and how do we overcome that to be able to say, you know what, we can be proud Indigenous and we can speak 3, 4, 5 languages. Mm-hmm. You know, we have a lot of internal racism on ourselves, and in the process of what we've been through over hundreds of years, we've taken on a lot of the racist thinking sometimes of the non-native or colonizers into our own fold also. And how do you see that? You know, people get very fearful of people who become too book smart or non-native smart, or and it's almost like they're afraid to grow and evolve and afraid that if I take this, then I'm going to lose this part of myself. There's that internal conflict sometimes I'm seeing even in my own community. And how do you see us being able to overcome those things and to convince people that to grow is to dream and to have everything, in the sense that we can have our culture, we can have our language, we can be strong, and at the same time be able to exercise our rights. That's a big issue, I think, in my community, that kind of divisiveness in our community and the fear of the outside. How do you think we could bring that back to have people unite more, not be so afraid of expanding and growing and making those relationships that I feel are vital? Because how I look at it, I'm proud of who I am, where I come from, but I also realize I'm part of a human race and part of a universal of humanity beyond who we are, and our traditions and our treaties respected that, and I don't see any reason why I shouldn't carry on and thinking that way, and yet still at the same time be strong and firm in our traditions also. How do we bridge that? How do we bridge that fear for people to be able to want to have that all, in a sense, and unite?
You know, I know after what happened in 1990, question. I didn't live through it because I was living outside of the community, but you know, I do have family and friends that lived through it, that it affected them, you know, psychologically. You know, and it's still, I would say, it's still there because of what happened. You know, over land and over. Basically, the government saying you're going beyond our policy of self-government, asserting sovereignty. It's basically what 1990 was about in a lot of ways. I think events like this, you know, this course that they've organized here is hopeful. The fact that they're focusing on looking at colonialism and issues around decolonization and listening to what Indigenous peoples have to say. You know, there's a website, Facebook page, because we use Facebook now. That's one of the technologies we have. Our people like to gossip and rumor a lot. And there's a Facebook page, I think it was started by some of the people from 6 Nations, called Indigenealogy. And that's what they're promoting, is Indigenous thinking about how do we adapt and develop and use these tools, but keeping who we are in doing that. And I think that's what we have to do. I think we have to learn information management. You know, we can do it in the language, the Mohawk language, but we still have to do it. We have to use these tools because the way I see it, I mean, basically, since the Brundtland Report of the World Commission on Environment Development in the mid-80s, the United Nations reports have been warning us that humans are affecting the biological processes of the planet. And that's what's led to the Climate Change Convention, the Convention on Biological Diversity. Internationally, they're trying to grapple with how do you get nation states working together to address these big global problems affecting our survival. But, you know, the plant and animal species that are facing high extinction rates now because we're destroying their habitats because of our lifestyles, aside from climate change. And we're all part of that. That's why issues of food security are coming up amongst Indigenous communities more and more. You know, I'm old enough to remember in Kahnawake when there were a lot of gardens and farms before all the houses, right? With the kids and the grandkids, and they're filling up the land. But we're going to have to get back to talking about like we used to do, and when we used to, you know, grow our own food. You know, instead of relying on California, it's on fire. You know, that's what I mean by self-determination plan. Each community's got to figure out how are they going to survive, be self-sufficient, develop their own resources. But that means we're going to have to challenge the outside governments. You know, I don't have that paper anymore, but a historian sent me this document from the 1830s. And it was about French farmers in Chateauguay complaining about Mohawk farmers from Kahnawake going and selling pig manure at a lower rate, you know, for fertilizer than they were. And they were writing to the white politicians asking them to stop the Indians from being able to go to market to sell their product. And that's what I always said about the tobacco. I said they didn't even want to sell them shit, let alone tobacco. So, you know, I wouldn't worry about what Ottawa thinks about, you know, our own developing our own goods and services. But, you know, they're trying to control the trade and commerce. They don't want to share powers over that. So we are going to have to reach out to Canadians. You know, sure, we'll have to be careful about who we make connections and become friends with. But, you know, Kahnawake always had friends, right, that have come from the outside to help. Even when the survival school started, I was there. I saw, you know, big hearts of people from the outside come to help set that up. And, you know, that's the kind of thing I think needs to continue. That's why I like networking, right? You don't have to form an organization, but you can network and have, you know, I don't know, friends of Kahnawake or, you know, friends of Indigenous peoples, you know, however you think it could go. Even early on in Canada, there was the Indian Eskimo Association. They were kind of paternalistic, but they developed a Native Law in Canada book in the 60s, mostly around those hunting and fishing cases. And then later on, they formed an organization to replace them called the Canadian Association in Support of Native Peoples. And then they changed that to the Canadian Alliance in Solidarity with Native Peoples, sounding a little more Marxist, but you know, the idea was the same. It was to bring people together to point out what the government was doing wrong. And for some reason in the 80s, that organization stopped, and I don't have proof of it, but I tend to think it's because the constitutional talk started. And our organization was being funded millions of dollars, and they had big heads because they thought, oh, well, you know, we're at a constitutional table, so now we're somebody. But meanwhile, all that money came from the feds. Right? As soon as that money was gone, they were back to being poor again, you know. But when those talks were going on, we focused on ourselves. You know, we were focusing on trying to define what our rights were in the Constitution. And we did that throughout the 80s. And working with allies and that, we didn't focus on that until after 1990. Then, you know, people started to come out and support us, you know, non-natives, as well as Indigenous peoples across Canada when that happened. So I think we need to do that now with this framework. Trudeau is saying, his government is saying they're going to talk to Canadians about this framework, so they're going to try and sell it. And I know a lot of Canadians who don't understand are going to say, what's wrong with these Indians? Justin's trying to help them and they're saying no? You know, what's wrong? But they don't know the whole story about, you know, what's the poison chalice, you know, what's in it. So I think we need to do that. We need to reach out and network. Because even in the two-row, we say, we're in our canoe, they're in their ship. Well, we better start talking about to the ones in the ship to talk to their government about the changes we want to see. Because if we're not going to do it, right, because it's their government, not our government, then we're going to need to get citizens aware, Canadian citizens aware of our rights and why it would be better for all of us to have a peaceful coexistence and prosper together, keeping in mind we're in, you know, a threatened time with climate change and what's happening, that we're going to have to change our lifestyles and consumer habits and try and do more about protecting our local area, because we're seeing more and more signs that we're in trouble on a planetary basis. And you know, I worked with Naomi Klein. I helped her on the LEAP manifesto, Art Manual, and I did, because we believed when the prices of oil went down, that's the time to start pushing for reform. Because when the prices of oil was high, you know, nobody in Alberta or anywhere wants to talk about shifting to solar or wind power. But now the price of bitumen and the tar sands has gone down, I think $15 a barrel or something. Now's the time to really start talking about shifting Canada's economy to something more sustainable than a pipeline that's going to cut through salmon-bearing, you know, rivers and streams and into the ocean. And we're going to need Canadians to step up with us on the environment issues, as well as the economic ones. That's what I think. That's what I've tried to do.
Thank you for all being here to attend this and for those questions that generated this note to end on. And Russ, thank you especially for coming. It's been very enlightening.
Thanks for having me.